just selected recording now. So as long as you're registered, then you should have received an email notification prior to this webinar with the recording, as well as after this webinar, you'll receive the link to the recording. There will be a master slide presentation that will be shared after the webinar series and will contain much of the same information that we are presenting today and in the past couple of webinars. Today, the presenters will be Mary Sprague, the Child Care Program Specialist from the Office of Child Care, Brad Kramer, Senior Business Analyst at the National Center on Subsidy Innovation and Accountability, and Teresa Campisi, me, National Center on Subsidy Innovation and Accountability. Before we officially get started today, I'd like to go over a few housekeeping items. We have over 200 people on the webinar today, so everyone will be muted. Please type any questions or comments you have in the questions box, and we'll either address them on today's webinar or we'll provide responses after the webinar. You may also utilize the hand-raising feature, and one of our organizers will unmute you. We will also have a few polls throughout the webinar, so don't forget to vote. And as a reminder, this webinar is a series of 3 webinars, and it's the final one. So if you haven't been able to participate in the previous 2, like I said earlier, the webinars were recorded, and this one is being recorded, so you will have the opportunity to listen to those webinars. And I won't take too long on the contact list, as I'm sure you all are sick of hearing about it, but each lead agency should have received a copy of the contact list, and they should assign a point person for the contact list. We've received probably about 15 responses back so far, either saying that the contact list is good to go or naming a lead person for the contact list. So if you haven't done that yet, please email me, tcampisi@wrma.com by November 13th, 2017, even just to say everything is good on the contact list, and we'll be good to go. I'm going to turn it over to Brad Kramer now.
All right, thank you, Teresa. Before I get started on the first topic, which is disqualifying crimes, I just wanted to take a moment. I know we were experiencing a little technical difficulties on our end as we were getting things kicked off. So I wanted to pause for a second and ask Mary Sprague if she had any opening comments that she would like to make before I get things moving.
Hi, everyone. Thanks, Brad. I'm glad that you all could join us for this last webinar in the series. I hope that you found them helpful. We've been getting lots of questions and comments, so I've been really excited to see all of the engagement on this topic. We're thinking that we'll have ongoing webinars so that we can continue to touch base and work through these background check requirements together. So thanks for joining. Thanks, Brad.
Thank you, Mary. Okay, again, my name is Brad Kramer, and I'm from the Subsidy Center, and I'm going to be covering the bulk of the material here today, pausing periodically for questions and answers from Mary. So the first slide we have here, disqualifying crimes. What this slide addresses is when is a staff member ineligible for employment by a child care provider. There are a number of circumstances related to the application and disqualifying crimes that should prevent an individual from being employed. The first off, even before we get to any background checks, if the candidate, potential employee, refuses to consent to the criminal background check, that's an automatic disqualification. Also, if that individual knowingly makes materially false statements in connection with the criminal background check, that also is an immediate disqualification. Moving on to the more criminally related instances for being ineligible, if the person is registered or is required to be registered on a state sex offender registry repository or the National Sex Offender Registry, that is reason for disqualification. Furthermore, if they have been convicted, and I stress the word convicted, not charged, if they have been convicted with a felony or a violent misdemeanor as identified as a disqualifying crime in the rule, that would also make them ineligible. And we're going to look at those particular crimes in the subsequent slides. Lastly, I do want to point out that states, territories, or tribes do have some flexibility to disqualify staff members based on convictions of crimes that may not be necessarily listed above. So at a minimum, the crimes listed on the subsequent slide are automatic disqualifiers, and states can add additional crimes that they see fit. So let's move on to slide 6, which is the list of felonies that the rule states are disqualifying crimes. Some of these hopefully are pretty obvious: murder, child abuse, and neglect, any crime against children, including pornography, spousal abuse, crimes involving rape or sexual assault, kidnapping, arson, physical assault, battery, or drug-related offenses committed during the previous 5 years. Those are the felonies that are included in the rule. And then for those violent misdemeanors committed as an adult against a child abuse, child endangerment, sexual assault, and any misdemeanor involving child pornography. So I do want to move to slide 8 before I open it up for the first set of questions and point out a couple notes here. Unlike the other requirements in the background check section, the Act only applies the restriction against employing ineligible child care staff members to those child care providers receiving CCDF funds. So the employment disqualifications do not specifically apply to to child care staff members of licensed providers if they're not receiving CCDF funds. So I'm going to pause for a second to allow anyone to put any questions out there. And then just a quick brief recap. We have the required felonies and misdemeanors. States have the flexibility to add additional crimes to those, and these apply to those providers who are receiving CCDF funds. So I'm going to pause and let Mary and Leanne observe the questions that are coming in and provide some responses before I move on to the appeals process next.
Yeah, thanks, Brad. So we've got a couple questions that have come in. So one is, what exactly is a materially false statement? So that's an area that we have not defined what that means. So the law doesn't define it, and the final rule doesn't define it. So that would be an area of state flexibility for you all to define exactly what a materially false statement is. This is kind of a similar question. Can you give any examples of crimes against children other than child pornography? So this is another area where we did not define the disqualifying crimes beyond what is included in the law. So that's an area where U.S. states can define exactly what that means. Let's see, here's another question about how these requirements apply. So I thought the background check requirements apply to all licensed, regulated, or registered providers. So that's correct. And this is one of the kind of complicated parts of the law, actually. So the law requires providers that are licensed, regulated, or registered, or receiving CCDF funds to meet the background check requirements. The only area where there's any difference is specifically for these disqualifying crimes. The law makes it very clear that these disqualifying crimes only apply to providers that are receiving CCDF subsidies. So that means that states have flexibility for providers that are licensed but not receiving CCDF. And we think that states will be able to have the flexibility to apply similar disqualifiers to those providers. Let's see, I think we have a couple questions about that. So the state has the option to apply the same employment disqualifications to licensed providers, whether they serve CCDF subsidy children or not, correct? So yes, that's correct. So the requirement is that the disqualifications in the law and the final rule only apply to CCDF providers, but that allows states the flexibility to also apply them to licensed providers who are not receiving CCDF subsidies. Some more questions about applicability. So do the disqualifying crimes apply to household members, or do they only apply to employees? So that's a really good question. So the way that the requirement works is that the disqualifications apply to all child care staff members, but included within that definition of staff members are those individuals age 18 or older in family child care homes. So the short answer is yes. The disqualifying crimes also apply to the household members, age 18 or older in family child care homes. So let's see, we have a really good question. As a tribal nation, we have our own federal laws and code of federal regulations regulating child care. These are different requirements. How do we resolve the differences? So I'm assuming that you're asking about has a tribe having a different set of disqualifying crimes. So for tribes, there's actually more flexibility here than for states or territories. So we applied all of the background check requirements to tribes, but because we've heard through consultation and conversations with tribes about all of the difficulties in accessing the checks, their own requirements around background checks, we gave complete flexibility in for tribes to decide how the background check requirements should apply. So that flexibility doesn't allow tribes to bypass the background check requirements, but it does allow them to propose some alternative approaches in their plans. So this area around disqualifying crimes is one of the areas where we're expecting we'll be giving flexibility to tribes. Although I will say we will not be, I don't expect that we'll be giving any flexibility around any of the violent crimes, especially the crimes against children. Okay, so let's see. Here's a question. May states deny CCDF based on arrest rather than conviction? So I think Brad mentioned this a little bit earlier, and we'll talk about it more in depth later, but the law allows states the flexibility to disqualify staff members and disqualify providers from CCDF for other information. So that would include arrests, and it would include convictions for crimes outside of these disqualifying crimes. But that's an area of state flexibility. Okay, let's see. So here's a question: what exactly is a CCDF provider? So that would be a provider that's receiving a CCDF subsidy. So here's a question about what happens if you have a pending case of a crime against a child. So the law and the final rule only speak to convictions for those felonies and violent misdemeanors. So that is another area of flexibility for you all to make that decision of whether you want to disqualify somebody based on that or not. We also had a couple questions from some previous webinars that I thought I might answer here. So how do states deal with findings from child abuse and neglect registries? So I think what this question is really speaking to is the fact that there's a requirement to check the child abuse and neglect registry, but being listed on that registry is not in and of itself disqualifying. So that actually gives a lot of flexibility for you all to make that decision given the information that you have. So this is an area where we've been really encouraging CCDF lead agencies to work with your Child Protective Service agency, the CPS agency, because they will help you in making that determination and will help you understand those findings. And kind of similarly to that, there was a question of about how do states interpret child abuse and neglect registry findings when they're getting that information from other states. So if an individual lived in another state in the past 5 years, that state sends their information from their child abuse and neglect registry to the state. How then does the state make a determination if it's not their own child abuse and neglect registry? So just kind of like the previous question, this would be an area where we would really encourage you all to work with the child welfare agencies in interpreting that information. Okay, I think we'll move on, but we'll continue to pause for questions as we go. So thanks, everyone.
Thank you, Mary. Okay, we are going to move on to the appeals process. I just want to talk about that for a moment. The topic here is what state must provide if a disqualifying result is received for a staff member. So whichever state is making the determination that an individual is disqualified is the state that's responsible for the appeals process. And the reason I bring this point up is because there may be a situation that we're going to talk about a little bit later where an interstate or a responding state is the one making the determination based on findings. But we'll talk about that in more detail briefly. The appeals process is based on accuracy and completeness. The state must provide information about each specific disqualifying crime to the individual, and that individual must also be given clear instructions, including timelines on how to complete the appeals process if they so choose. And then it is that state's responsibility for verifying the accuracy of the information that happens to be challenged by the individual. And I just want to reiterate here again, I know we've covered this before, but it is prospective and current staff members that are subject to these requirements. Moving on to the review process. What options do states have for drug-related felony offenses committed within the past 5 years? So if you'll recall, that was one of the crimes listed there. States do have the option to use an individualized review process to determine if individuals convicted of drug-related felonies during the previous 5 years should be eligible for employment by a CCDF provider. So depending on the circumstances around that crime, the states do have some flexibility there. Next point here is that the review process is different from the appeals process because it allows the lead agency to consider extenuating circumstances on a case-by-case basis. States should consult the U.S. Equal Employment Opportunity Commission's guidance on review processes. One more slide before we pause for questions again. And this is one more slide on additional disqualifying crimes. States have the flexibility to consider additional disqualifying offenses when making employment determinations. That lends back to what I mentioned previously, where we have the defined list and then states can add others as they see fit. If they do so, the state must at least offer some type of appeal process for those additional disqualifying crimes, just as the ones listed in the rule. And last point here, states are encouraged to implement an individualized review process for any other disqualifying crimes not listed in the Act. And in addition to challenging the record for accuracy and completeness, as an individual review does allow the lead agency to consider some other relevant information. And I want to, before I do open it up for questions, or as I do open it up for questions, we're going to go back one slide because I think there may have been a lag in the slide changing for you on your screen. I did cover these points, but I wanted to make sure that you all had a chance to actually see the slide and review it. So with that, this does bring us to our next Q&A session. So I'm going to turn it over to Mary to address any new questions that may have come in.
Okay, so as we're waiting for more questions to come in, there's a couple questions that were asked a little bit earlier that I can cover right now. So we had a couple questions about minor records. So do the disqualifying crimes include minor records? So this is another area that we did not specifically address in the law or the final rule, and so this would be an area of state flexibility. So generally, the child care staff definition applies to anybody who's employed by the child care provider who provides care and supervision for children or unsupervised access, or is an individual age 18 or older in a family child care home. So for some states, they may be required to search for staff members who are under age 18 who are caring for children. Okay, let's see. So this is one about applicability. So what about family child care providers? Do we need a background check for everyone age 18 or older in the home? So the answer to that is yes. The requirement is any individual residing in a family child care home that's age 18 or older is required to have a background check. And it's also subject to these disqualifying crimes if that provider receives CCDF subsidy. Okay, so here's one about those the interstate background checks. So can you talk about how a state can make a determination for somebody who lives in another state? What if states have different disqualifying crimes? So we're going to talk a little bit about that first part on the next slide, so I'll just kind of pause on that. But for states that have different disqualifying crimes, so I guess there's kind of two pieces to that. So one, states may have different definitions of crimes, and they vary from state to state. And so this would be an area that we would really encourage you to work with your state identification bureau or your state criminal justice agency, the law enforcement, in understanding those state definitions. Okay, so let's see. I think the other part that I was going to say about that, so states do have, because states have the flexibility to add on other disqualifying crimes, there are states may be using a different set of standards from state to state. And so this is something that we'll address on the next slide, but essentially there's a little bit of flexibility there in how you handle that. So maybe we should actually move on to that next slide, Brad, since we're getting a couple questions about that.
Okay, thanks, Mary. So I alluded to this a little bit earlier about the potential for some other state being one of the interstate requests making a determination. And that's what this red light, green light refers to. There are states that are closed record states who may not be able to share back with the requesting state what those results are. And so they have the opportunity or the option to potentially make a red light, green light, or yes, no, qualified, disqualified result based on their findings without actually sharing their findings. So that's kind of a little bit of a background on this topic. But to get to the points on the slide, most states have adopted FBI security policies and standards to protect their own state criminal data. Those laws and policies can often be a barrier to sharing that information outside of their state border. And so responding states can determine whether the individual is eligible or ineligible for employment given the state background check results. But I do want to call your attention here to a special note, though, that the responding state may use additional disqualifying crimes that are not listed in the final rule for the purpose of determining eligibility. So we have already talked about states have the flexibility to add crimes, and so that state could be making the determination based on one of the additional crimes that they have added that may or may not align with the requesting state's crime list. Based on those results, the responding states disclose the determination, red light or green light, to the requesting state without revealing the specific crimes. If the individual is deemed ineligible by that responding state, then that responding state is also responsible for notifying the individual and following the appeals process. So that's a lot of information to absorb on just that one slide. And so we are going to pause again for those questions coming in.
Okay, while we're waiting for questions about red light, green light, or sharing results across state lines, we have a question about what meets the requirements for an appeals process. So I think it might be worth just kind of reiterating what Brad was saying earlier. The appeals process, which is the process that states are required to follow for all of the disqualifying felonies except for drug-related offenses committed during the past 5 years, and also they need to follow the appeals process for all of the violent misdemeanors. And so that the appeals process that's outlined in the law is just based on accuracy and completeness. So it's not a review process. Those disqualifications are all lifetime bans. And so the appeals process just allows individuals to challenge the accuracy and completeness. For drug-related felonies that were committed in the past 5 years, there's a little more flexibility. So for those, states have the option to do an individualized review process. So that process kind of allows the lead agency to consider any extenuating circumstances and to review case by case whether that individual should be eligible or not. Okay, I'm just reading through the new questions that have come in. Let's see. So here's a question: which state makes the final determination? If one state says they're disqualified, then it is over. What if another state says they're eligible? So when you are a state receiving a red light, green light response from another state, it's merely a red flag, because you don't, we recognize that states may be using additional disqualifying crimes that may not apply in your state. And so when you get that red light from another state, when you hear that they would be disqualified in that other state, there's some flexibility in how you consider it, but certainly it should be considered a red flag. Okay. Let's see. So here's another one. Can applicants give permission to states where they've lived prior to share background check information? So the answer to that is yes. And you've also reminded me that in addition to this red light, green light flexibility that states have, when there's a closed record state. We've also allowed the flexibility that in those instances, the individual can go back to the state where they previously resided and ask for their criminal history record and bring that to the determining state. And that's certainly not something that we would recommend, because it does open up the possibility for fraud, but that is an option that's open. Let's see. So let's see, if they're a closed record state, how will we be able to tell what the crime is? In order to make a determination, we need to know what the crimes are. So actually, this is something that we've heard a lot from states, and the red light, green light was our attempt to come up with a compromise. So what we've been hearing when we were talking to states is that they were willing to share a red light or green light response. So they would be willing to share, yes, the individual is eligible in our state, or no, the individual is not eligible, but they were not willing to receive that from other states. So the preference is definitely to be able to receive that state's full criminal history record for the individual. So that's definitely something for you all to keep in mind, and we're continuing to work on this interstate challenge, and continuing to kind of try to think through how we can best support you all in making these determinations. Let's see. So as I'm watching more questions come in, there were also some other questions from previous webinars that I also thought it might make sense to address, because they came up so often on our previous two webinars. So we talked briefly about provisional employment on our first webinar, and we've gotten a couple questions about that. So generally the questions are, can a person work before all of the background check information is completed? So the final rule has requirements around provisional employment. So after an individual successfully completes either the FBI fingerprint check or the state fingerprint check of their state's criminal repository. So once they complete one of those two checks, and by complete we mean the state has run the fingerprints and reviewed any information that's come back on their criminal history record and determined, based on that information, that person is eligible to work. So once they've completed either of those two checks, they can begin work as long as they're supervised at all times by somebody who has completed a full CCDF background check. So we also got a lot of questions about the National Sex Offender Registry, and so we talked a lot about that on our second webinar. And the group of questions around that is generally which National Sex Offender Registry check will actually meet the requirement in the law and the final rule. So as we discussed, the National Sex Offender Registry is a file within the National Crime Information Center, the NCIC. And the requirement is for there to be a separate name-based check of that National Sex Offender Registry. That registry is maintained by the FBI. It's part of the National Crime Information Center. An FBI fingerprint check will check the fingerprints of any of those listings in the National Sex Offender Registry, but our understanding is that there are a small percentage of cases that don't have any fingerprints attached. And so that's why there is that requirement to do a separate name-based search of the National Sex Offender Registry. The National Sex Offender Registry is not a name-based search of the National Sex Offender public website. So the public website is maintained by the Department of Justice, and that it acts as a pointer to state and tribal sex offender public websites. So it's a real-time pointer to those websites. Okay. Let's see. Here's some more questions that have come in. If a state is not adding additional disqualifying felonies in their state and is only defining in the CCDF disqualifying terms, can they indicate that they have not added any state-specific felonies when communicating a red light? So yes, that's definitely an option, and we would definitely encourage that, because the more information that you're giving to a state, the easier it will be for them to make a determination. So if you're telling them, we're a closed record state, we're not allowed to give you this person's criminal history repository, or criminal history report, sorry, but we're giving you a red light and we're only using the federal disqualifying crimes, then that would be a better indication to the receiving state when they're making their own determinations. Okay. Well, I know we have a few more questions, but I think I will turn it back to Teresa to keep us moving.
Thanks so much, Mary. So again, this is just a resources slide that we've been sharing the past couple of weeks. The resources are the background check requirement highlights, the PIQ clarification on CCDBG Act background check requirements and health and safety training requirements, the Child Care and Development Fund, the final rule, frequently asked questions, and the PI on implementing the National Crime Information Center National Sex Offender Registry background check requirement. And of course, we have a couple of polling questions. The first polling question is, would you like webinars on criminal background checks to continue? So I'll go ahead and launch that. So the options are monthly, quarterly, or no. Okay, so I'm going to go ahead and share the results. It looks like 48% said yes monthly, 51% said yes quarterly, and 4% said no. So the next poll we have is, do you have a best practice you'd like to share with the group? So we've got yes, no, or let me think it over. And I'll share those results. We have 82% at no, 0% at yes, and 18% at let me think it over. So if you're one of the let me think it over, definitely feel free to type any of your ideas in the questions box or on the evaluation after we end the webinar. Sorry about that. And the final polling question, do you have a best practice you'd like to share specifically around provisional employment? So let me launch that. When you're voting for that, you may want to consider how has your state overcome the requirement for not hiring someone until after they receive either their FBI fingerprint or their in-state fingerprint check. Has your state had to work with an FBI-approved channeler for fingerprints to increase the number of fingerprint sites throughout your state? Or what policies has your state changed to become compliant with this requirement? I'm going to share this. And we have 2% at yes, 64% at no, 7% at let me think it over, and 28% at no, but someone please share because we need help. So again, I encourage you to type any of your comments into the questions box again or on the evaluation when the webinar is over. So on that note, the polls are complete. We do, of course, want to thank you again for participating on these webinars. And I will let Mary have any final thoughts or closing remarks.
Yeah, thanks, Teresa. So we've been continuing to get questions as we've been going. And I wanted to note one final question or comment that we got. Has states implement their rules? It would be helpful to share that information with other states so that they can go out and learn from them. And so I think that's a really good point, and that's one of the reasons why we're asking you all about any best practices that you'd like to share, because as we're planning future webinars, we'd really like to have more states sharing kind of what they've done and what they've struggled with so far, because that's probably a better way to learn than just to listen to me talk about this. But I wanted to thank you all so much for your participation and for asking questions. And we're continuing to try to provide resources and support and to work with you all as you're implementing these requirements. So even though this is the end of this 3-part series, we're going to continue this and have more webinars in the future so that we can continue this conversation. So thank you all so much.
Thank you, everyone.